Hey, how you doing? Oh, just quickly popping out there to the shop. Just busy in here today between calls. So I've just been doing a video chat there with a local guy, really, you know, from the northeast, from a place called South Shields, on the mouth of the River Tyne, but on the south side. But you know, he's a spiritual guy. He runs like a healing center and crystals, sells crystals and stuff. But they're doing a big event and at Newcastle Racecourse. You know, and there's a lot of different things on there, like healing and speakers and stuff like that. You know, it's a great event. It's on the have a check on it. It's like Paul Wilcock. I'm doing a chat with him, so you can have a check on the video, you know. But he's on there just promoting the event. First weekend in April it is, so not that long away. Newcastle Racecourse, huge, great venue, loads of car parking, so go have a look, check it out, get yourself along. And I was talking to him, and I'm quickly popped out, and I'm going back. I'm going to have a chat it's very soon, about an hour, with Pete Stone. You may know him as Sovereign Pete, so another good friend of mine. I'm going to go and have a quick chat with him, get that up on the channel as well. And it's all full of busy. And then just after that as well, I have to go and speak to allegedly Dave. So we've got some really good videos coming up and going out over the next couple of weeks, so keep an eye out for them all. You know, we had our private members club meeting last night. We have 2 a week, one on Wednesday, one on Thursday at 7:30, and we go over sort of like, you know, whatever is the topic. But what we're talking about, among other things, private trusts, or it's like, you know, all trusts are private if they're created by you or even solicitors. But this is the thing, you know, I've been speaking to a lot of people lately, and they've had a discretionary trust created. Nothing wrong in that, you know, absolutely nothing wrong in that. I'll explain discretionary later, but the solicitors say, yes, it is a private trust, you know, we're creating that privately between me and you. However, okay, as all trusts are private, yes, but then the solicitor will go off and he will register it with what they call the Trust Registry Service, which is another word for, another phrase for saying HMRC. So although he's telling you, yeah, private between me and you, then he's going to run off and he's going to register it. So what he's done is he created a statutory trust, which is not private whatsoever. It's under statutory legislation. Then he's registered it with HMRC, which are going to want to know all the facts about your trust. Does that sound very private to you? Does that sound like, well, I have a lot of information about me I don't want anyone to know because it's my private information? So now you've went and registered it with the Trust Registration Service, or with like HMRC, because it is them. Is that private? Is that the kind of privacy that you're actually looking for? Eh? So, yes, technically, all right, you can say that all trusts created by us are private, but not private as in actually non-statutory. We are not going to be showing them the details of our trust. So just bear that in mind when we've got people trying to muddy the waters with that BS, okay? And the same thing, I mean, you know, like, oh, I've got to show you, I can't show you now because I'm in the car. I've got, adding on to my library, we have got, like, you know, quite a lot of books now, like on the trusts and equity, and explaining, because there's two sides of equity. I'm not going to go into it and confuse you with that now, but we do teach an equity side of things in our private members club meetings, you know, and we record everything and it's all kept in there. You can see it. And hang on, just going to get past these two. Oh, don't like that. There we go, through. through the traffic. Quite a bright sunny day, isn't it? It was beautiful this morning. We're out a little bit later than normal, 6:45. I was so drained today when I woke up, and I think I had a good night's sleep. I don't know what it was. But anyway, went out and it was lovely. And then all of a sudden, by the time we get home, you're seeing the light zoom, 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 and the next thing, you know, everything's completely bloody grey again. But no, I mean, it's quite cloudy now, but we are getting some breaks in there. So I've got my solar panels out all over the garden, getting the energy. Got the batteries charging up. But yeah. So and we were discussing sort of like the trusts and everything about the privacy side, like I've just mentioned, but also we were talking about the Recognition of Trusts Act 1987, and also the Senior Courts Act 1981 on chapter 49. Whoa, that was a bit close, mate. Yeah, so on the Recognition of Trusts Act, now again, look, just bear in mind, okay, this is what trusts are recognised under. Now we're in England, okay, so we're talking about English trust law, which goes across the UK, England, Wales, Scotland, you know, but I mean, they call it English trust law, okay. Now under the Recognition of Trusts Act, that is how they recognise trusts. Now the main reason why they put this in was about the EU and everything, but like, let's not go wandering off all over the place. Now your trusts, even if you've wrote it down on the back of a cigarette packet, it will be recognised as a trust if you've written it out correctly. But bear in mind, you have two parts of your private trust. Okay, you have two parts of your trust, a private side and a public side. So on the private side, when you are doing your documentation, when you are doing your deed, right, you do not write into it these acts and statutes. You don't write that in there, right, because it's a private document and you want it to be private. We are creating a non-statutory trust, therefore you're not going to write statutes inside of it, okay? I've always said that, but like obviously people again trying to muddy the waters and put a lot of confusion out there. So we don't write that into the trust deed. However, the fact still remains that under the Recognition of Trusts Act 1987, the trusts are recognised. All trusts are recognised. And as long as you're writing it out correctly and not making it a sham trust, then you're going to be totally fine with it. You know, and I'm exaggerating, written on the back of a cigarette packet, but, you know, it's just trying to actually get people to see, you know. And in that act there, if you go and read through it, on the government legislation, not me saying it, and it tells you point blank on there, and the way that it is written, and it says, the settlor may choose the law that governs this trust. The settlor may choose the law that governs this trust. That's what it says, point blank, written in black and white. So, you know, we were discussing this like with my tutors, we'll call them. So the ones that, like, you know, I'm in a few different courses as well as reading the books on trusts, making sure it's clear, and it doesn't say anything else about where you're living, where you're sitting, where you're standing. It says point blank in black and white, and this is coming from my tutors as well, not just me. And it says in the legislation, the settlor may choose the law that governs the trust. Now, all trusts come under the jurisdiction of equity. However, you may choose the law that your trust is governed under wholly. So we actually put it in there exclusively, solely and exclusively under the jurisdiction of equity, because it is a non-statutory trust. It's not coming under statutory legislation. Now, I know that they're all governed under equity, and equity is a huge case of law, all right, huge group of law. But just bear in mind that what I'm saying, that the actual Recognition of Trusts Act 1987, sorry, I just had to get past that car there, I'm not ignoring you. It states point blank, go and read it for yourself. the settlor may choose the law that this trust or that trust is recognised under, governed by, whatever. Go read it. Okay, hang on, I'm going to get round here as well. Don't reverse on me. Get out of it. There you go. Yeah, so, and then if you go into the Senior Courts Act 1981 and have a look at that. And again, this is just to show you what things are governed under. We do not write acts and statutes into our trust because we are doing it solely under the jurisdiction of equity, and we are doing it privately. However, right, we are still going to be recognised under the Recognition of Trusts Act 1987 because that is the statute that all trusts are recognised by as long as you've written it out correctly. But we do not write it into our private documents, obviously. Okay? So yeah, and this is what was, funnily enough, and it was getting discussed like in my like that I attend, so like where I still go over the trusts, and I'm taught how to actually write them correctly. I'm taught how to define them, between the difference between a statutory and a non-statutory, a public and a private trust. And I mean public as in the solicitor has took it off and registered it with the HMRC. Do you want your trust registered with HMRC? Well, I suppose you would do if you've done a discretionary trust and you wanted to actually have like it going through the will and the solicitor and everything like that. Then yeah, fine, do it. And there'll be reasons why you'll do it, but there are other reasons why you wouldn't want to do it for other people. Strange thing is, everybody's not the same, isn't it? So the way we're actually writing them, because the way we want it, we don't want it registered with the Trust Registration Service or HMRC as it really is. They've got the nose in enough of our business anyway, haven't they? Come on. So, the less we know or have to tell them about everything else, then the better it's going to be. So have a look at it. Read those. But remember, if you're doing your own or you've got someone to do it for you, don't write that into the actual documents. Now, on the public side of your trust, what you want to do is you need to have something that you can publicly state to people that there is a trust in existence. This is the difference. Now, if you're having a public document, and we could call it like a public statement, public notice, all right, whatever you want to call it, okay? And saying here, this is a notice of interest, or this is a public notice, and this notice tells you that there is a trust created, or that there is a trust in existence. You can make up the wording as you want, but it's a notice that you can put in the public, that you will allow to be public. So it doesn't have to be showing all the information of your private side of the trust. Who are the beneficiaries? Don't have to tell them. What are all of the assets? Don't have to tell them. But if somebody's coming to be nosy about, say for instance, your car or your house, and remember, like property is the highest right of man. It states it in that book, the English law, that property is the highest right of man. I'm going to read that book out to you soon, and it's like the English law dictionary, not Black's law. Although there's nothing wrong with Black's law, it tells you that Black's law is American and English jurisprudence, but right, this one is specifically for English trust law. English law. Hang on, get through here. Now, on that notice that you're going to do, where you will be allowed to share it like publicly with, like, say for instance, the council. I don't know, I'm making it up. Right, let's just say that what would it be? Well, let's just say that they wanted to do something about the house. Just say you've missed payments on your council tax. I don't want to go down that route. I don't want to talk about it whatsoever. But let's just say that they had actually expressed an interest to your home, right, on the land registry. So they can actually make inquiries. Just bear in mind, the land registry, all right, they are not a governing body, governing ing on the end, and they are not an authority. They are simply an agency that collects information, and then they sell that information to other agencies, right? Like the councils, which they do all the time, and to HMRC and to debt collectors. They sell that information to solicitors and these insurance companies that are doing investigations to see where your assets are, right? All of them, they just sell it, okay? And you can get what they call property alerts from the land registry, which are free of charge, right? And you should all have them if you've got yourself registered on the land registry. And what happens is they'll send you an email and tell you somebody's inquiring about your property, so you'll get to know, and you'll get a fright when you actually end up with, like, you know, some charge put on it or whatever. Okay, so but anyway, so let's just say that they've made an inquiry. Then what you can do is you can issue this notice, which is going to be in the public. So let's just call it a public notice then, okay? Or a public statement, whatever one you want to call it. And it's saying to the council, in this example, it could be like a debt collector, it could be a solicitor, whatever, right? And you're going to say, oh, this trust, it is in existence from such and such a date. We do ours through the Royal Mail. So say we've got proof of Royal Mail, you know, tracking number, blah, 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 that it's been delivered to the trustees. It's now in the possession of whatever it is. Anyway, we've actually got good examples of a notice that you can give to people, companies, corporations that are being nosy about your assets. And it tells them that all interest, rights and interest has been passed to the trustees. It's all held on trust. You don't need to give them the name of the beneficiaries, but there would be no harm in telling the name of the trustees, because the trustees have got to be in public anyway. The trustees have to argue your case, so you have to tell them. But this is a public side, you know, so you can tell them that, right, okay, this is my fact that there's a trust in existence, and the trust is in existence. Here is the notice to tell you, and the trust name is there, set up from that date. If you want to inquire about this asset, which has a reference number, a title reference number, because all assets have to have a reference number, an individual reference number, okay? So we know that from that that case about, like, the London Wine Company, that they actually lost all of the wine because they just said all of this is held on trust, but they didn't have each individual bottle or barrel or whatever it is that, you know, that they lost. I think it was bottles, because they were investment bottles, you know, like they do it, investing in wine and whiskey and stuff like that. And because they hadn't given them all an individual reference number, they lost them all to the bankruptcy hearing. So they must all have even if you've got just one house and you want to put it in, give it a reference number. Or if you've got a lot of buy-to-lets, give them all a separate reference number. Or I would actually put them in separate trusts, but you forget that part, you know. Let's just say that you give them a separate reference number. They all have to have their own title. And then you would hand that, and the information about the trust exists. This is the reference number, and this is the trustee's name, and here is the email that you need to write to. This does not form part of the estate of, and write, you know, the name, if that's what they were inquiring for, because that's obviously what they're trying to do. Okay, so in there, right, what you're going to do is, like, you can be a bit more open, because that's your public notice to state that there's a private trust in existence. All right, but on the documents for the deed and whatever else that you've got, the assignment of your assets into on trust for a named beneficiary, you do not write down acts and statutes. Okay, you just don't do it. And, you know, because it keeps it out of there. Now, you know, when someone says, well, if you do anything whatsoever that could be assumed as a public act, right, and that ties in there, well, tell me, how would you write your trustee's name down, or how would you write your legal fiction down? Whereas a legal fiction itself, by definition, is a public act. By the Birth and Death Act, whatever it's called, the Registrations Act, if you've got a name, which your name itself then has been created into a corporation, fingers crossed you all know that, with your capitalized thing, but that means then every single time you use your legal fiction, you are using an act, a public act. So there's no way to avoid that. So you're kind of pretty done and dusted. But that's actually BS anyway. So all you have to do, are you coming this way or what? I'm gonna go, yeah. Oh, you're going, you're turning. Thank you. All right. Yeah, but like when you're creating the deed, you're creating the actual expressing the deed, you're creating the deed and the assignment or whatever it is, or else the documents you're creating for your trust. You don't write acts of this and acts of that, and I'm, you know, like Human Rights Act and all of that. You don't put any nonsense like that in whatsoever, okay? Because that's the private side. But remember, you can do a public document that you can actually show to people that are being nosy about the assets, where they might think that your car is forms part of your estate, or the house you're actually just living in. Well, you're just living in it. It doesn't form part of your estate. Well, you can show them the public side. Two separate things, right? But anyway, more information can be found if you go and have a look at our Checkmate the Matrix. That's our new program. So I'm going to shoot off now. I'm going to get ready for my interview there. We're going to go and see, have a good chat with old Pete Stone. Take care, and we'll see you later.